Session 5. Comprehensive lecture on compliance risk control, legal red lines and pitfall avoidance for newcomers in non-performing assets. Opening introduction 5 minutes. Dear all, over the past 4 hours, we have fully broken down the industry landscape of non-performing assets, market dividends, 4 viable business tracks and the full process disposal practices. Many new learners feel the business tracks are clear and profit generating paths are well defined, and they cannot wait to connect with clients, source projects and start making money. However, I must emphasize this point. The non-performing asset sector is a financial subdivision under strict supervision and legal restraints. The prerequisite for making money is to stay compliant and avoid legal troubles. 90% of newcomers in this industry suffer losses not from failed projects, but from crossing legal red lines and compliance loopholes. Consequences range from confiscated commissions and compensation for client losses to administrative penalties and even criminal liability. This entire hour will not cover profit-making skills. It will only focus on compliance rules to protect your business. The content is divided into 5 major sections. Compliance red lines for practitioners' qualifications, legal boundaries of debt negotiation, transaction risks of foreclosed properties, contract risk prevention for intermediaries, and daily operational risk control procedures. All sections are illustrated with real lawsuit cases and law enforcement penalty cases, and every rule must be kept in mind by anyone entering this industry. Part 1. Compliance red lines for practitioners. Qualifications 12 minutes. We first distinguish 2 roles: pure information intermediaries and debt negotiation service providers, which carry completely different qualification requirements. Most newcomers make mistakes at this very first step. First, pure information matching, only connecting asset holders, property owners and clients without operating on their behalf or collecting funds on their behalf. Individuals engaging in non-performing asset information intermediation do not need financial licenses, making this the only zero-threshold legal track for ordinary people. Nevertheless, 3 mandatory restrictions apply. 1. Prohibition of false promotion. Do not promise 100 debt relief, guaranteed low-cost acquisition of foreclosed properties or guaranteed fund recovery. Such promises will be deemed false financial promotion, subject to market supervision, fines ranging from 5,000 to 20,000 RMB. Here is aerial case from Qiantang district last year. A local intermediary posted short videos claiming full credit card debt relief. A debtor filed a complaint, triggering an official market supervision investigation. The intermediary was fined 8,000 RMB and all his social media accounts were restricted. 2. Prohibition of forging qualifications or impersonating law firms and asset management companies AMCs. Many newcomers download lawyer certificates and AMC authorization documents online for promotional use. This constitutes forgery of official documents, attracting administrative penalties, and may lead to criminal liability in serious circumstances. Act as an individual intermediary honestly, and do not affiliate with or false lie claim to represent other institutions. 3. Prohibition of collecting client funds, deposits or advance payments on your own behalf. This is the highest risk red line. No matter if clients wish to pay property deposits or consultation service fees, never accept such funds through personal bank accounts. Compliant practices include third-party fund trusteeship or corporate account collection. Commissions shall only be settled after signing an intermediary agreement and upon successful transaction completion. Collecting large sums of personal funds may be deemed a legal financial operation. Second, mandatory qualification requirements for debt negotiation and overdue installment agency services. Many industry entrants focus on sorting out liabilities for debtors, and negotiating installment plans with banks. A critical reminder: individuals without a lawyer's license or financial mediation institution filing record cannot independently provide agency services for overdue installment applications or debt litigation representation. Banks only officially recognize two types of entities: licensed practicing lawyers and licensed financial mediation institutions. Individuals may only provide liability sorting, consultation, and policy guidance, and must not negotiate with banks or sign documents on clients' behalf. Real risk avoidance case: a practitioner based in Hangzhou collected thousands of RMB in consultation fees from hundreds of clients and negotiated with banks on their behalf. The case was transferred to law enforcement by the Banking and Insurance Regulatory Commission. The practitioner fully refunded all service fees and was additionally fined 20,000 RMB. Third, qualification requirements for 4 closed housing and property disposal tracks. Individuals may conduct property viewings and transaction matching, but they are prohibited from issuing property appraisal reports or providing bridge loan services. Bridge loan services fall under private lending financial businesses. Operating such services without relevant qualifications constitutes illegal business operations, and high interest rates will be identified as usury. Part 2. Legal boundaries of debt negotiation businesses. 13 minutes. The debt consultation track attracts the largest volume of potential clients for new practitioners. We will detail all permitted and strictly prohibited operations, with a side-by-side comparison of legal and illegal practices. Lawful and executable operations fully permitted for individual intermediaries. 1. Sort out all client liabilities: credit cards, online loans, mortgage loans, private lending for free or a fee. Compile liability lists, repayment schedules, and overdue penalty calculations, and provide only data sorting consultation. 2. Interpret debt-related provisions in the Civil Code and banks' personalized installment policies, and inform clients of their legitimate legal rights. 3. Provide communication script templates and guide clients to negotiate with bank customer service independently, with all communication conducted by clients themselves. 4. Explain legal procedures after overdue payments, including lawsuits, compulsory enforcement, and property seizure consequences. As risk popularization, strictly prohibited illegal operations. Penalties will be imposed once violated. 1. Impersonate clients to call banks and online lending platforms. Forge client income certificates, hardship certificates, or medical records to apply for installment relief. 2. Charge clients high guarantee fees or connection fees, claiming internal bank connections to reduce outstanding debts. 3. Provide bulk debt agency services under the name of a legal team without formal cooperation with a licensed law firm. 4. Instigate clients to cut off contact with creditors, default on debts maliciously, or transfer property to resist court enforcement. This is an extremely serious red line. Anyone who abets refusal to enforce court judgments shall bear joint criminal liability. Supplementary practical suggestions for those wishing to provide in-depth debt negotiation services. 2 compliant solutions are available. First, cooperate with a local licensed law firm, with lawyers conducting bank negotiations. Second, only provide pure consultation services, with all negotiation operations completed independently by clients. The service agreement shall clearly state that we only provide knowledge popularization and shall not act as an agent for any financial businesses. Part 3. Top 10 common risks and risk control measures for foreclosed property transactions. 12 minutes. After earning a certain amount of commission, many newcomers shift to matching foreclosed properties, which carry the most legal property right and creditor's right pitfalls. I will break down each risk with real foreclosed housing cases in Hangzhou. 1. Risk of long-term rental agreements. Sales cannot break valid leases. Many foreclosed properties carry 10 or 20-year low rent leases. Successful bidders cannot take possession of the property after auction. Intermediaries must conduct full due diligence, retrieve real estate registration documents and court caesure files, and specify lease terms and service agreements. If risks are undisclosed to clients, clients may file lawsuits to claim compensation for commission losses. 2. Hidden costs from outstanding arrears. All unpaid property management fees, utility bills, heating fees and land transfer fees shall be borne by the auction buyer. During due diligence, you must visit property management offices to check detailed arrears and inform buyers in writing. 3. Difficulty in relocating original household registrations. Original property owners may refuse to transfer their household registrations, and courts have no authority to force relocation. This will affect buyers' children's school enrollment and household registration. Clarify this policy to clients in advance and include it in risk disclosure documents. 4. Property right defects. Co-owned property. Joint marital debts. Properties under minors' names. Some properties are auctioned without the consent of co-owners, who may file enforcement objections afterward and block property transfer. Full retrieval of complete court case files is mandatory during due diligence. 5. Hidden mortgages and secondary caesures. Beyond primary bank caesures, properties may carry secondary caesures from private usury and micro-loan companies, leading to far higher debt settlement costs than expected. A detail easily overlooked by new practitioners. Supporting risk control operations. Issue unified property risk disclosure form for every foreclosed housing listing. Clients must sign to confirm full acknowledgement of all risks prior to signing the intermediary contract, and retain signed physical documents to avoid subsequent disputes. Part 4. Standardized intermediary contracts to avoid 90% of client disputes. 10 minutes. Most newcomer losses and client complaints stem from non-standardized intermediary agreements. Oral commitments hold no legal validity. Here we cover 4 core mandatory clauses and prohibited clauses for contracts. Mandatory contract clauses. 1. Clear definition of intermediary service scope. Only information matching risk popularization and property viewings. No profit guarantees. Guaranteed transaction completion or warranties of flawless property rights. 2. Commission settlement terms. Service fees shall only be collected after full property transfer or official bank approval of debt installment plans. Full refunds shall be issued if agreed targets are not met. 3. Self-risk taking clause. Non-performing asset investments carry risks including price fluctuations, policy changes and blocked enforcement. Clients make independent investment decisions voluntarily, and intermediaries shall not be liable for investment losses. 4. Fund clause. Clearly state that intermediaries shall not collect any deposits, housing payments or security deposits. All funds shall be transferred directly between clients. Prohibited contract content. 1. Principal protection. Profit guarantees or buyback commitments. 2. Promises to eliminate overdue credit records. 3. Promises to foresee evict tenants or relocate household registrations. 4. Excessive high liquidated damages, exceeding the scope of legal protection. Supplementary practical tip. Retain all online chat records, offline interview recordings and signed physical documents for at least 3 years. Complete records serve as core evidence for exemption from liability in the event of complaints or lawsuits. Part 5. Long-term daily operational risk control system. 6 minutes. After covering legal and contractual red lines, we will introduce a simple daily risk control workflow executable by individual practitioners before accepting each client to eliminate risks at the source. 1. First client contact. Distribute the risk disclosure form and require full reading before providing any services. Do not collect fees or make promises in advance. 2. Standardized project due diligence. For property projects, retrieve seizure files, property arrears and lease information. For debt projects, verify clients' real liabilities and never forge supporting documents. 3. Daily self-inspection of promotional content. Review short video and social media copy daily, and delete extreme promotional words such as guaranteed profit, 100 debt relief and full guarantee. 4. Fund segregation. Do not accept large business payments via personal WeChat or bank cards. Apply for an individual industrial and commercial household corporate account if possible. 5. Regular policy learning. Policies issued by the Banking and Insurance Regulatory Commission. Courts and market supervision BaROs are updated continuously. Set aside time each month to study new regulations to avoid outdated operations that trigger violations. Closing summary of the 60-minute session. 2 minutes. This entire hour centers on compliant business operation. The non-performing asset industry, BOA Street's substantial profit margins, yet it is subject to strict regulatory constraints. For zero-based individual practitioners, 3 core survival principles to remember. Never collect client funds on your behalf. Never act as an agent for financial businesses. And never make false profit promises. Compliance is the foundation of long-term profitability. Ignoring legal red lines may bring quick client orders and short-term gains, but a single administrative penalty or lawsuit can wipe out months or even years of income. In Session 6, we will cover the full operational implementation plan for individual practitioners, including individual industrial and commercial household registration, compliant short video account operation, and private domain conversion, teaching you to expand your client base legally and secure steady, sustainable order intake.